Thank you, Kirti, and it's really a delight to be here talking about these critical issues. We're going to vary the format a little bit from this morning's panel, so I'm going to spend a few minutes, before launching into the panelists, just doing a little bit of historical stage setting. I'm not going to try to cram 100 years of patent antitrust history into 10 minutes, like I sometimes do. But I will start 25 years ago in 1994, January 1994, when Ann Bingaman, then head of the Antitrust Division, announced the formation of an IP task force to write IP guidelines. And those guidelines really continued the process begun under Bill Baxter of aligning enforcement policy with economic insights that have been developed yet a generation before that in the academy with scholars like Ward Bowman and Bill Baxter himself. And there are really four key themes of those guidelines that stand out in my mind as particularly important, and I think it's worth revisiting them 2.5 decades later. One you've heard about, you heard a little bit of a snippet from Josh Wright in the video clip that began this afternoon session, and Judge O'Malley mentioned it too, that we sometimes refer to patents as the patent monopoly, and the point that the guidelines really wanted to emphasize was that patents and intellectual property generally is not monopoly, it's property, and sometimes it forms the basis of monopoly and sometimes it doesn't. And I think there's been a bit of backsliding in that area. And you see constant references, even in the Federal Circuit, which wrote the Atari case, which we quoted in the guidelines about IP being property, not monopoly. They have taken to referring to it as monopoly again. And I think that's a little concerning. Second, the guidelines addressed how to characterize the distinction between vertical and horizontal relationships. So horizontal relationships between competitors. You heard Judge O'Malley a few minutes ago express some surprise about there seemingly being more concern about prices being set among competitors than between licensor or the unilateral behavior of a licensor. But I think what the guidelines emphasized was that you have to judge whether a relationship is horizontal or vertical by whether the companies would have been competitors absent the license. So it addressed what is the right but-for world. And I think there's a tendency in sort of common approaches to this area to think of antitrust analysis as focusing on what would have happened absent the restraint. And really the right but-for world is not what would happen if all of the innovations are already invented and all of the insights are disseminated through licensing, and then you ask, well, what's the effect of this restraint? It is to ask, what would happen if the licensing had not occurred at all? What had happened if the initial investments had not occurred? And there were many who argued, including government officials who were involved in the process, for an absent the restraint standard, but Rich Gilbert and the rest of us at the division were pretty adamant about the absent the license formulation, which I think is the right one, and I think there's been backsliding in this area as well. Third, the guidelines had a view about what licensing contributes. A fundamental precept of the guidelines was that licensing is pro-competitive because it allows bringing together complementary inputs in the hands of multiple actors. And this is, again, an easy lesson to forget, but we don't want to disadvantage innovation models that depend on licensing vis-a-vis those in which the inventor can fully exploit the invention itself and make money, monetize the invention by selling stuff. And you heard a bit about it this morning as well. One of the key points about licensing is that it enables specialization. And you heard about Edison and others, but it's a common story that the innovators bring certain strengths, implementers bring certain strengths, and if you undermine licensing, you shift investment incentives away from those innovation specialists, if you will, toward those who can monetize by selling things. And from the perspective of 25 years later, I think licensing is really easy to forget the value of because the human mind tends to favor things you can see, hear, and touch. And it's something that we need, I think, to be terribly vigilant about. And fourth, the guidelines focused on the effect of a practice, not in this platonic sense of that practice floating in the ether, but in the context of specific markets. And so the guidelines were strongly anchored in the rule of reason, and what had come before in the 1970s in the US was the 9 no-nos, and in Europe, the black, white, and gray lists. And it was focused on the practice as if a particular kind of practice was bad in and of itself. And the guidelines tried to step very much away from that and anchor itself in the rule of reason. And you can all judge for yourself whether there's been backsliding in that area as well. So I've alluded to Europe. In the 1990s, the US was clearly not the only country thinking about these issues. While the guidelines were being written, and shortly thereafter, the patent regulation and the know-how regulation were expiring in Europe, and the European Commission was in the process of formulating the technology transfer block exemption that went into effect in 1996. Also in 1996, the Canadian Competition Bureau held a workshop in Ottawa to bring together scholars and enforcers from all over North America to talk about those issues. And after a pretty extensive consultation process, they issued the Intellectual Property Enforcement Guidelines in 2000. Those guidelines were a little closer in spirit to the US guidelines than to the technology transfer block exemption. But you still had overtones of particular kinds of issues or practices that drew their attention, things like tying arrangements, for example. A year later, at the OECD, a policy roundtable was held, and lots of representatives for all over the world, Japan, Korea, folks from Poland, a number of others. And there was a wide range of attitudes expressed there. I think the Japanese delegate put in a submission referring to their guidelines, which was a lot closer to the 9 no-nos approach on grabbags and vertical price restrictions and restrictions on parallel imports and the like. The Korean submission advocated the use of competition law to, quote, put the brakes, close quote, on excessive protection of IP and evince great suspicion of tying and grab bags and vertical price restraints, output limitations, and other practices. But overall, I think bringing folks together and having all of the agencies talking to each other at that time seemed to be to nudge agencies in the direction of more sophisticated economic analysis and greater respect for the benefits of intellectual property and of contractual restraints that facilitate licensing. I will leave to the panelists their assessment of whether the same is true today or whether the agencies are simply egging each other on to more aggressive and less circumspect enforcement. And with that, what we're going to do is have some opening remarks from each of the panelists. I'm going to start with the economists and then turn it over to the lawyers. And then we'll have some questions from the moderator and then open the floor to the audience, although anyone in the audience with a burning question from the moderator question period should feel free to jump up or raise their hand or whatever, and we strive to be flexible here. So with that, let me turn things over to Jorge.
Thank you, Will. So this panel is about global agency dynamics, and my contention today is going to be that the way that the authorities and antitrust agencies over the world have been thinking about intellectual property, and in particular I want to focus on the issue of standard essential patents, has been largely driven by developments in the legal and economic literature, influenced by legal and economic scholars mainly based here in the US. And not surprisingly, because that research focused on the allegedly welfare-reducing effects of patent holdup, agencies had been focusing on patent holdup as well. That research, as I mentioned before, was focused on the potential exploitation of the IP rights in the hands of patent holders in the context of standardized industries, like the smartphone industry. In that literature, patent holdup is inherent to the standardization process. It's a theoretical necessity, and as such, it is regarded as an empirical reality, not because there is empirical evidence, but because it is a theoretical necessity. Frank commitments in that context can serve one and only one purpose, and that is to moderate, mitigate, or eliminate patent holdup. And antitrust agencies were persuaded of these ideas and were enthusiastic when they were told that the only way that that power could be limited, that patent holdup could be corrected, that Frank commitments could be made meaningful, was if they intervened in order to ensure that the full benefits of standardization were materialized and that the value of standardization was distributed equitably within consumers. And we had a series of cases reflecting those ideas. Earlier on, back in 2005, the European Commission case investigating excessive royalties. That is, whether the Frank commitment had worked or had been abused, breached to the detriment of consumers. The problem with those early cases is that there was no clear-cut definition of what Frank meant. The agencies were persuaded that there was patent holdup because it was a theoretical necessity, but didn't know how to identify it because nobody had defined properly what was the meaning of Frank. And the best candidate available, which was the ex-ante benchmark, was clearly not operational at all. The theory moved, and recognizing that problem, evolved in a way that tried to deal with patent holdup without having to define what Frank was. And it evolved in a way of trying to advocated limiting the bargaining power of the patent holders. If patent holdup is a theoretical necessity and we need to correct for it and we don't know how to recognize it, at least let's try to intervene and limit the bargaining power of the patent holders. How? Limiting, for example, their ability to use injunctions. How? Imposing caps on royalty rates by defending something called the SSPPU combined with the top-down valuation approach. And finally, trying to eliminate or rule out or make it impossible for patent holders to use any source of leverage, whether in the market, in the innovation market itself, or in any other adjacent market. It may sound familiar because I guess that we are seeing that in California these days. The patent holdup school and the agencies that followed them faced and still face a fundamental problem. And that fundamental problem is that there is no evidence of holdout. The industry whose development should have been hampered by this pervasive patent holdout is actually thriving, is doing well. There is no evidence that value is being appropriated exclusively by patent holders. There is no evidence whatsoever that consumers are not benefiting from the standardization process. In fact, that is not the only problem. That is the problem that we have emphasized for years and years, but there is a more fundamental and important problem, is that there is evidence that shows unambiguously that if there is a problem in the industry, that is that of holdout, not of holdout. Many potential licensees, many implementers get away without paying for the intellectual property that is embedded into their products. Many of them delay agreement. They insist in patent by patent litigation, jurisdiction by jurisdiction litigation, with the sole purpose of delaying agreement. Many of them are refusing to engage in mandatory in arbitrations these days, or in anything that sounds like or gets closer to having to pay. The evidence of holdout is pervasive, unlike the evidence of patent holdout that is missing. And yet it is neglected. And one shouldn't be surprised that it is neglected by the scholars that develop the holdup theories, because they are likely to be committed to those theories because of ego, because of ideology, or financial support. But what is more surprising is that that evidence is ignored by the agencies. One potential explanation is that holdout is said to be a contractual problem and not an antitrust problem. Interestingly, that statement is made by the same people that year after year insisted that holdup is an antitrust problem and not a contractual problem. Now let me state it clearly. From my perspective, holdout is clearly an antitrust problem. And it is clearly an antitrust problem because it meets the two requirements that are needed for it to be an antitrust problem. First, because it can distort the competitive process. And it distorts the competitive process to the extent that it biases competition and R&D against companies that are not vertically integrated, against companies that are not practicing entities and focus on R&D. And second, because it meets the second requirement, that it hurts and harms consumers. And it hurts and harms consumers because it denies them access to those innovations that could be made and developed and commercialized into the market by people that are not vertically integrated. Holdout is not merely a distributional problem. It's not just about transfer of rents from patent holders to licensees. Holdout, it is an antitrust problem. Why is not capturing the attention of the agencies? I think that it is not capturing the attention of the agencies because unlike the school that developed holdup, we don't have a school that has developed clear ideas about what holdout is and what it is problematic, and has not explained why the incentives of implementers regarding the timing and scope of negotiations is decoupled, is separated, is not aligned with the incentives of societies. Because people have not explained that companies have an incentive to hold out, among other things, to deny resources, deny competitors the resources needed to develop their own R&D. Because delay has an option value, since technology may evolve and workarounds may develop. Nobody has explained that companies that are engaged in holdout have the incentive to engage in patent by patent litigation in order to exploit externalities across patents. You get one patent declared invalid today, that basically means that you're improving your bargaining position and your litigation position with respect to all of the patents in the future. And the same incentives exist across jurisdictions. And we need to explain very clearly that those that favor patent by patent litigation and litigation jurisdiction by jurisdiction, what they want to achieve is actually to achieve delay. They want to engage in practices that would lead to the undercompensation of investments, and actually that is most likely to be the case when the patents in question are strong. Because if they're weak, then the incentives to engage in holdout are much less, because you can resolve or you can obtain as an implementer a good outcome just through a normal negotiation or an arbitration where there is a global patent, global license for the entire portfolio. We need to explain, therefore, what are the distortions of the competitive process that holdout generates. We need to explain more clearly what is the consumer harm that is generated, and we need to develop theories of harm that can help the agencies focus on what is empirically relevant as opposed to what they have been persuaded it is theoretically plausible. Thank you.
All right, thank you, Jorge. Luke?
Yeah, thank you very much, Jorge. Just what he said. So I just want to expand a little bit on what Jorge said, and what some other people have said here today. Jonathan Barnett and several other commentators have, and just to talk a little bit about just the big picture is that Robert Solow won the Nobel Prize, I think in the 80s, for his work on growth. And he's famously said, you know, adding a couple of tenths of a percentage point to GDP is going to swamp anything that economists are otherwise concerned about. And he wasn't talking about antitrust, but he certainly could have been, because what we're concerned about, you know, are relatively small things relative to the innovation that drives the growth rates of our economy. And just when we talk a little bit about the balance, you know, we're going to talk about the balance between hold up and hold out. It's a double-sided bargaining problem. You have both, you know, both issues going on, and which is worse. You know, when you talk about, you know, getting the balance of that right, you really should keep in mind the overarching theme here is that innovation, you know, an increased, you know, more favorable legal environment for innovation is going to swamp any kind of antitrust marginal gains we make by, you know, screwing around at the margins here. The one thing I want to add to what Jorge said, you know, how do we get to this point? And he rightly blames kind of famous U.S. scholars. He didn't want to name them. I'll call them out. Carl Shapiro. You know, he developed his hold-up model to really talk about the uncertainty associated with enforcing a patent. And you know, models are tools. They're good for some jobs, not for others. But the model was then applied to the problem of how do we divide up the rents from innovation. And you know, it had been used for this one purpose, which wasn't bad, but then using it for this other person, it's the wrong tool for the job. I mean, the thing that makes it so awful and just so embarrassing as an economist that people are using these kind of tools is that it takes innovation as given. Okay, so we've got a tool that takes innovation as given, and then looks at the implementation problem. You know, how do we implement it? And as Jorge said, the only possible harm in that model, in that characterization of the bargaining between the innovator and the implementer and the consumer, the only possible harm is to the implementer. There's no possible harm to the innovator because the innovations already occurred. And to use that model to talk about IP rights and the effects of IP, I think is just an embarrassment. And as sooner we kind of get this word out, and just it's awful. And I think it's exacerbated by the bargaining that he was talking about is exacerbated by stuff we heard this morning about the lack of injunctive relief. If I can't exclude you from using my patent, you know, you basically replace the hypothetical negotiations of the court with the actual negotiations that would occur if we were allowed to exclude, if IP holders were allowed to exclude others from using them. And I think that That's about all I have to add to what Jorge said.
All right, we're now going to turn to the lawyers, and let me start with Jenny.
Okay, thank you. First of all, thank you so much for the invitation to come and speak here today. A lot of has been said about the US system, so I thought that I would maybe focus a little bit more on the European system with my remarks. But I want to start by saying that the remarks that Jorge made about the lack of empirical evidence of hold up, I very much agree to that. And the fact that there is a massive holdout problem, I also agree to that. I witness it every day in my work where I head the patent business of Nokia, and I think it's something that's been present for 10 years, and for some reason the competition agencies have failed to fully appreciate it. But nevertheless, I think it's helpful to sort of remind ourselves why some of these discussions and regulatory discussion sort of got started. Around 10 years ago, and I think Jorge was also alluding to this before, the principles of FRAND were really not very clear. At the same time, I think people could clearly see that there could be a potential problem of hold up, because there were lots and lots of patent holders contributing to the standards, and it was very possible that one single patent holder, potentially with one single patent, would come and seek an injunction, get an injunction, and impose astronomical royalties against an implementer. And I think, in fact, that we had one of those cases. We were working, or I was working as a competition lawyer back then, and Nokia was sued by a company called IPCom. And they sued us in Germany. Germany had a so-called bifurcated court system where claims on infringement were heard prior to invalidity, and basically you could get an injunction with an invalid patent before the invalidity argument actually got heard. So there was a problem, and this company was behaving very, very aggressively. I remember having discussed this case with the European Commission back then, and this was back in 2008. And one of the officials in DG Comp told me, basically sent me home, saying that the Commission will never intervene in the question of injunctions. Well, it turned out a little bit differently later on. So what actually happened was that circumstances changed in the market, and there was actually quite a bit of turmoil. Some of the early pioneers, like Nokia, went under, were forced to exit the mobile phones business, and we would have new powerhouses emerging and becoming to dominate the market. So we had companies like Apple emerging with its closed ecosystem that then ultimately ended up taking the lion's shares of the profits of the market. And then elsewhere we would have Android and Google dominating. And some of these companies, they had not been involved in creating the wireless technologies that were discussed and introduced earlier in I guess it was the first panel, but there had been other companies doing that. So the new entrants had a strong incentive and interest to try to devalue the IP that existed in the market when they entered the market. So what we saw was a start of a massive lobby campaign that I would say has continued until the very day and still continues. And I think that the purpose of that lobby has been simply to aim to devalue the existing IP, irrespective of whether there actually was an antitrust problem or abuses on the side of SCP holders. So the implementers went to the antitrust agencies and start telling this story about this massive problem of hold up that could theoretically be there. And I think that it was very easy or I don't blame about people about having bought into that story, because you could have this hypothetical problem of hold up. And in fact, there had been some incidents of opportunistic behavior in the industry, and the principles of FRAND were not clear. And many people were saying that we don't really know how these things should be resolved. So I think the antitrust authorities, they spotted a problem and they wanted to fix it. And now the question is that were the tools that were taken into use, were those the right ones, or did the intervention actually go a little bit too far? And I would say that I think it did go a little bit too far, despite the fact that probably the intentions were very good. I think that there were a couple of, or at least 3 mistakes that I think that were made. So the first one was really that people were kind of so concerned about this hypothetical problem of hold up, and they really bought into it that they kind of lost sight of really looking for the empirical evidence, as Jorge was alluding to. I still haven't seen to date a credible study being made about or showing that there actually is, in a sort of bigger picture, sort of a big problem of hold up in the industry. It's still lacking, or we are still searching for it. I think the second mistake that happened in the competition law intervention was that the competition agencies focused solely on looking at the behavior of the standard essential patent holders. Because they thought that that's actually the problem that would be the antitrust problem. If people on the other side, on the side of the implementers, would be behaving badly, that wouldn't be an antitrust question in their view. That would be rather something that should be decided by the courts. So they never really focused on that side of the storyline. And what that then resulted into was that I think that the regulatory discussion started to predominantly be about SEP behavior and how the SEP holders were behaving badly, and sort of nobody was really speaking strongly enough about the behavior that we were seeing on the other side of the table. And then finally, I think the third problem with the antitrust cases that we saw coming, in my view, was that they were solely focused on the SEP negotiation situation, hold up, hold out, and all of that, but they were totally ignorant about sort of the other kind of a countervailing power that implementers could have, things that you would normally in any antitrust case look for. You wouldn't be reaching decisions about somebody being dominant without looking whether actually that company can be behaving completely independently of everybody else, or whether some of the companies it's interacting with actually have countervailing power. And I think that's something that has been fully and completely missing from the antitrust cases, and I think it still continues to be that. I think that's actually very much visible in the case that the FTC has brought against Qualcomm. The discussion then moved on. I think in the EU it culminated to the landmark judgment of Huawei ZTE that was handed down by the European Court of Justice. And luckily so, and very good for Europe, I think that judgment then struck the balance pretty nicely, very well, between the different interests of the SCP holders and the implementers. What it did was that it laid a framework for the courts to sort of, sort of the principles how they could be following when they are deciding on the cases. I think that it's working very well in Europe, and what we're now seeing is that the various different courts are applying it in the individual cases and in individual European member states. In Germany, we have seen quite many cases coming out where the German courts have been issuing injunctions, but we've also seen some cases where the German courts have taken the view that the patent holders have not, or the SCP holders have not given enough information to the implementers before having sued them, so they are sort of sending them back and saying that the case is not yet ripe for them to be granted an injunction. In the UK, the courts have taken a little bit a step further, and in situation where there has been no FRAND offer made available by either parties, so they have themselves decided to construe what could have been, or what is the right FRAND royalty in the case, and then they are sort of asking the implementer whether he accepts it, and if they don't, they have granted injunctions. So I think in Europe, we at the moment have an environment that's, broadly speaking, I mean, it's not perfect, but I think it's functioning, and I think it's striking the balance pretty nicely. Which then brings me to the US, where I think that the environment that we are seeing here at the moment is such that it appears very unfavorable to innovators. Before coming to this panel, I was asking around my colleagues that what are really the problems, and what I keep hearing and what we've heard also today are that first of all, it's extremely hard to get an injunction, and it's very much that when you are suing with a standard essential patents. When the courts are determining or deciding on damages on standard essential patents, so they have been awarding royalties that are significantly smaller than what, for example, the European courts have been awarding. And then also sort of from a practical standpoint, I think it's very costly to be litigating in this system. We've seen what has happened in the IEEE after, I think, when unfortunately sort of the pretty, in my view, imbalanced IPR policy was introduced and got some endorsement here in the US by the government. So that has resulted in a situation where I think that the IP environment is really hampering the technical work and the development activities. And in fact, just very recently, sort of an IEEE technical specification was not certified by ANSI because some of the central patent holders have made so-called negative declarations saying that their IP will not be available under the current IP policy, which is a problem if then people need to sort of be implementing it. So I'm not finger pointing any single person or action that kind of led into this situation, but rather that I think when you take the entire system as a whole, it does not seem to be encouraging for innovators. I think at large part, this is due to the fact that some companies in the US have wanted to shape the system to serve their own interests rather than taking a longer term perspective and advocating a system that would be more balanced. And I think they've invested a great deal in doing that, and gradually they have created an environment or helped to create an environment that really favors the viewpoints of implementers as opposed to innovators. I think a couple of recent, let's say, themes, as example, I think that the patent troll and the NPE agenda that was very strongly pushed here in the US, just from a company's point of view that has been innovating and that has been really in a constructive spirit trying to resolve some of these issues. So having been seen how that's being used against companies that actually are behaving in a perfectly legitimate manner, and how sort of if you are divesting some of your IP to an NPE that kind of used to be a perfectly legitimate business model is now perceived to be something very bad, and you are being sort of, people are accusing you of antitrust violations or making you look bad. So it's something that you are very much facing here in the US. I think the other example of an sort of an implementer-friendly agenda that's been very, very heavily pushed here in the US is the smallest saleable unit agenda. I think this was introduced sometime around 6 years ago by some pretty powerful companies who wanted to pass on the IP cost burden to their suppliers. At the same time, they are pretty much squeezing their own suppliers who don't have high margins or who cannot really pay for the value of the IP, and all of this then kind of serves to devalue the IP of innovators. So I think these are just some of the examples, and I guess against this background, I think that it has been quite, let's say, refreshing to follow the intervention of the Assistant Attorney General Delram Makrahim, and I think that the reason that he is being so vocal is because he is really concerned about the state of affairs in the US and thinks that the system is out of balance at the moment. And I think that some of the policy changes changes that he's suggesting will be helping to steer the direction back to the more balanced situation that used to be there and restore some of the rights that the innovators traditionally have enjoyed in the US. Thank you.
Thank you, Jenny. And I think some of Jenny's comments may be a perfect segue into those who have been the targets of the folks trying to get governmental action in a particular direction. So let's start with Maureen.
Great, thanks, Will. So I don't want to reiterate what a lot of my fellow panelists have already covered, so let me just touch on a few things lightly. Luke, you mentioned this idea that taking innovation as a given, right? That, oh, it doesn't matter, the strength of the IP right, all these good things are just going to be created anyway. I often heard the phrase, oh, you have a faith-based belief in the value of IP, right? There's no evidence there. So the article that I mentioned in the previous discussion with the judge is called Patent Rights in the Age of IP Skepticism. And it looked at all the studies that I could find that tried to measure as patent strength waxed and waned, investment in R&D, and using that as a measure. And there was definitely a correlation. It was present in some industries more than in others, but it was certainly present in all of them. So I do think when we're talking about IP and antitrust, we need to understand that the IP protections do help create dynamic competition down the road. But with that being said, then what is the right role for antitrust? Because I feel that one of the problems that we have experienced in some of this debate about IP and antitrust is on the one hand, having a lack of clarity about the value of IP rights, but also, on the other hand, a lack of clarity about what antitrust is supposed to be about. So I gave a talk a couple years ago called What Are We Talking About When We Talk About Antitrust? And so often people sort of leap to the idea that, well, someone has market power, right? Or they may even have a monopoly, whether we call it the patent monopoly or not. And gee, that's what antitrust is supposed to be stopping. That's the bad thing. But that's not right, right? That is really a caricature of what antitrust is supposed to be about. Now, if you have market power because you have created a wonderful invention, you should be able to charge possibly even a monopoly price for that, right? And that's what the Supreme Court in the Trinco case and other courts have recognized. And when we talk about antitrust not being price regulation, I think that's one of the issues. But where has antitrust, I think, played an appropriate role in IP? So when we talk about a case like the FTC's activist case about pay-for-delay agreements went all the way up to the Supreme Court. Well, you were probably at the FTC at the time. Or the FTC Commission's recent decision in the 1-800 contacts case. The way I look at those cases and where I think antitrust should be playing an appropriate role is you can't expand the boundaries of your IP right by agreeing with your competitors that they should be this much farther out. So you can't say, well, my IP right, you can never challenge it, right? That was sort of the activist case, right? I'm going to agree that not to have a challenge to the strength of my IP right. Or you can't get your market power by deceiving the standard setting organization, by putting your IP into it and not telling them it's IP, right? Not telling them that you have a right there. But the problem that I see when you lose sight of what the real goal of antitrust law is, which is to stop the exercise or accumulation of market power not based on competition, not based on winning on the merits by having the better invention or providing the better service or what have you, but merely saying having a strong market position is in itself a problem, is that we then kind of quickly go to an essential facilities doctrine. The idea that, oh, I have to have access to this to compete in the market, so therefore you are required to share it with your competitor, even apart from if you ever put it into a standard. So when I've traveled around the world and talked to people, and as they see these cases, they kind of often jump over the part that the debate is often about, well, what did it mean when you made a FRAND promise? What did it mean when you put your IP into a standard? They kind of say, oh, well, I thought competition law was about having more competitors, and if you need this right to compete, therefore we should have access to it. And GR law also has an unfair pricing mechanism. So you pretty quickly get to the idea of compulsory licensing at a rate that particular regime wants. So I think those are some of the dangers when we're talking about global agency dynamics that we might face when we lose sight of what antitrust law is supposed to be doing, in the IP space or really any space, as well as losing sight of the idea that IP does, far from detracting from competition, is often a spur to dynamic competition and innovation. So I'll stop there.
Bill?
All right, well, thanks, Will. Thanks for having me today. It was nice to look through the program and see that we had representatives from all three branches of government today, which is cool. I'd like to, again, offer apologies for Macon not being able to make the fireside chat today, and for Judge O'Malley and Director Iancu for being so flexible. Thank you, Maureen, for also helping pinch hit during the session. I thought it was great, and making sense is best. I also should add that the views I expressed today are my own, not those of the Department of Justice. One thing which I should throw in, Will, you mentioned the role that Ann Bingaman played in creating the task force which led to the initial IP guidelines. As it happens, tomorrow we're dedicating the Ann K. Bingaman Auditorium and Lecture Hall at the Department of Justice in a big ceremony that we're having during spring meeting while everyone's in town. So you'll probably see some news about that soon if you haven't already. So again, well, to your question, what are the agencies doing? Are we in an enforcement race, a race to the bottom, race to the top? And I think that question does take on a global perspective to the point that Jorge was raising. And for better or for worse, antitrust is one of the United States' greatest exports. And of course, we see competition regimes using it in different ways. And so for that reason, the antitrust division has been heavily engaged in advocacy on these exact questions of antitrust and IP. And of course, our goal throughout this is to advance civil debate into these contentious issues and about what role, if any, that antitrust should play in policing licensing disputes, and then even more broadly into other questions about whether antitrust should reach coordinated conduct in a standard-setting context. So last year, along these lines, we launched what we call the New Madison approach to antitrust and IP. Luke was there at the time. And that approach is premised on the idea, just the very basic idea that many of you have touched on, that antitrust and patent law do share the same underlying goal of protecting and fostering dynamic competition. So we followed up that announcement, of course, with a public advocacy blitz, both at home and abroad. And we've certainly seen it foster a lively discussion with some commenters and letter writers reaching out to us directly, coming in for meetings and otherwise. Often we'll hear people say, well, Macon's views on IP. Just to be clear, a speech by the Assistant Attorney General sets forth the policies of the United States, not just the views of Macon. And I think that's something to keep in mind. And ultimately, these are the policies that we're really trying to advance in all this dialogue. But moving forward, as we've been getting into 2019, we've started turning our policy advocacy into action in a few ways so far, with more to come. First, as was discussed earlier, we withdrew our assent from the 2013 DOJ PTO Statement on Remedies for Standard Essential Patents. And then second, we're actively seeking out opportunities to weigh in court disputes, whether it's at the district court phase or the Court of Appeals phase. So in January, during the shutdown, we filed a notice of an intent to file a statement of interest in a litigation in Southern California called U-Blocks versus Interdigital. That case, it's a fact pattern I'm sure many of you are familiar with, even if you've not read the complaint in that case. It involves a Sherman Act claim for an alleged breach of a FRAND commitment. It also has the additional allegation of deception based on a Broadcom versus Qualcomm claim. And we noted just briefly in that one-page notice of an intent to file a statement of interest that we want to take on those claims head on. So we will be filing that statement of interest at the appropriate time. So stay tuned on that front. As these efforts play out, like I said, we're thrilled to see the conversation evolving to allow serious consideration of the possibilities of both hold up by patent holders and hold out by licensees. I think that's a good thing. I think panels like this, conferences like this, which are taking seriously these claims and really probing deep into the underlying theoretical and empirical evidence are very valuable for that debate. So with that.
Okay, let's turn to some questions now. And actually, my first question is for you, Bill. I think on an earlier panel, we heard John Barnett mentioning that he perceives DOJ's shift in this area, whether it's a 2013 policy statement or the renewed or perhaps new focus on holdout, as being based on actual evidence. I'd like to hear what sort of evidence are you looking at? What are the findings? How does that evidence inform the current policy?
Yeah, I think it's on a few fronts, and obviously I can't comment necessarily on any investigations, whether it's public or private, that we might have, or what outside parties come in and speak to us about. But it happens a lot. The parties bringing in evidence, and to Jorge's point, we hear a lot of anecdotal evidence on this point, and and we're also looking carefully at what opportunities there might be to work with academics, whether it's within the EAG department of the Department of Justice with all of the 60 economists that we have, to sort of expand the empirical analysis of these questions of holdout versus hold up. So that's something that we're considering expanding. I mean, we came to the table as this debate really was, starting to evolve, and I don't think the last words have not been spoken on the question of hold up and the empirical basis for that. By the way, I should note I saw Greg Sidak back there, and I recently read his "Is Patent Hold Up a Hoax?" article, which I think touched on a few points that were mentioned on this panel, and it was really terrific. He does not mince words, which is certainly an understatement. But again, I think we're seeing it in conversations with parties that we have all the time. We're seeing it in as part of our investigations, and it's something that we're taking seriously, and it's something that we're trying to better understand and analyze the scope of those things.
Maybe the economists want to comment on this one too, in terms of what the empirics are showing?
I think that if you have been in this business, if you have participated in arbitrations or antitrust cases, and you have had the opportunity to look at what is the average time that it takes to complete a negotiation, what are the many different actions that implementers undertake in order to delay payment, etc., then it's obvious. It's not anecdotal. It's all over the place. And I think that that's the reason why I was claiming before that the evidence overwhelmingly indicates that there is a holdout problem. At the same time, when we look at the evidence of holdup, the first thing is that you don't see implications, the sort of implications that you would expect in terms of a market that where there is no output, where prices are going up, et cetera, et cetera. None of that happens. And secondly, I think that, and very importantly, the people that complain, the companies that complain about very high aggregate royalty rates have never put forward the sort of evidence that I would expect to see, which is their aggregate royalty rates and how their aggregate royalty rates compare with the total value that is generated by the technology. And so if you are the complainant, you have the evidence and you don't show it, that tells me that that evidence doesn't seem to suggest what you are claiming. Whereas I think that, as I mentioned before, the evidence about holdout, it's all over the place.
Yeah, the evidence on hold up is just, it's a theoretical possibility, and it just you know, the evidence is, well, things would be better if we didn't have holdups. So there's a theoretical possibility relative to some counterfactual theoretical, and we don't know. I mean, there's no claim that that theoretical counterfactual that we're allegedly moving closer to is going to reward innovators for doing the essential business of innovation, and that's absolutely critical. And the hold-up arguments, the models can't even address that because they assume the innovation is given. It's just nonsensical.
But if I may add, I think that we need to move from the statement. I fully agree with everything that Luke has said, but I think that if this debate is to progress, we need to move from the repeating once and again that there is no evidence of hold-up, because as Luke is saying, that's always going to be questioned with, but in an ideal or in a hypothetical counterfactual, things might be different, to emphasizing the massive evidence of holdout. I think that that's where we should put our focus on that evidence of holdout, because that has no explanation other than there is excessive bargaining power and bargaining power misused from the viewpoint of society on the part of a number of implementers.
Annie, I think you want to say something.
Well, yeah, and I would maybe like to just add that I think what would be very helpful from the side of the antitrust agencies is that when you are actually looking into the cases, because that you would really focus on looking at the facts. And when complaints are being brought to you that are like completely detached from reality, and when there are no facts to support those complaints, and believe me, I've seen many of them, so then under those circumstances, it would be very good if somebody actually was vocal about it rather than just lets the things go, because you have kind of had a situation where the SCP holders have needed to defend themselves against all sorts of meritless accusations in the industry for a very long time, but there actually never seems to be or competition authorities are not coming up with decisions where they actually would be telling that this is a fact. So I think that in order to have a more balanced conversation and regulatory discussion about these things, it would be very helpful that the fact that there's a lot of claims being made, complaints being filed that are completely detached from reality, that somebody would actually say that that's true, it would be very helpful.
So Jenny talked about the one instance that she saw very early on in which there really did seem to be this kind of opportunism by a patent holder, holding up opportunistically implementers who had already made the investments, right? Why is that so rare? I mean, I don't know of anyone else who's actually come up with a good example like that. Is it because this was not a repeat game for that player? Or is there some other reason why this, what seems to be a very logical story of Cornell compliments and all of that, just hasn't panned out in practice? Anyone have reactions?
Well, I think I would have a first comment. Perhaps Jenny can help me here, but I don't think that IPCOM was that successful at the end of it.
No, I think what sort of resolved the case then was that ultimately that patent was found invalid, but you nevertheless sort of faced there maybe the threat of injunction in a country. But I think that case is from 10 years ago. Since then, a lot of things have happened, including what we have gotten in Europe is this Huawei ZTE judgment that really then clarified some of those principles. And I think that what's important to understand is that the FRAND as a concept was created already, 20, 15 years ago, and that was supposed to be the remedy to the possible potential hypothetical hold-up problem. So it is there, and I think that with the court cases coming up, we are getting those principles clarified even further. I think the Huawei ZTE judgment was very good because I think it did clarify some of the principles very well. And I think since then, I think the environment has improved. So I think that in the current circumstances, it is actually extremely hard to go there with an SCP and try to enforce it in some sort of a very abusive manner, because you just simply will not be successful, and there will always be, at the very least, court scrutiny happening before you get an injunction granted.
So would the whole problem be solved if the U.S. simply adopted Huawei v. CTE and Unwired Planet v. Huawei, and sort of problem solved and we're done?
Well, I mean,
If only it were so simple.
right. It would be a good step, I think, along the way. But
Okay, and what problem do you think would remain if you know, if we put those into place as worldwide laws and not just European laws? What would we have left to solve?
Well, I think that Unwired Planet, for example, does a few things that are helpful, but it doesn't get all the way. So I think that on the one hand, the idea of having a global FRAN license that deals with entire portfolio eliminates lots of the possibilities for holdout, and in that respect is good. Yet there are issues with the interpretation of non-discrimination in FRAN that are potentially problematic, and I think that that's something that needs to be considered. And also the core issue of how to value the intellectual property and what is the right way of determining royalty rates is a little bit up in the air, even following those judgments.
Well, looking at the time, we've got a bunch of other issues that we'd love to talk about, including Jorge's comment about antitrust, appropriately dealing with the holdout problem. And I don't know whether you're talking unilateral or coordinated there, Jorge, but maybe both. There are lots of issues raised by the behavior standard setting organizations that Jenny touched on. Well, we're way out of time, and I wish we could spend another few hours discussing these questions, but please join me in thanking this panel.